counsel on a pro bono basis for the purpose of auditing the legal implications of the current moment of silence during board meetings. You have the cover sheet in your backup. With that, I'd like to introduce Ken Kukowski with First Liberty Institute and introduce our board members, Supervisor Rocky DeWitt, Jeremy Taylor, Marty Pottebaum, Keith Braddock, and Pat Gill, County Auditor and Clerk to the Board. So the action requested is to accept the pro bono services of First Liberty Institute to provide a confidential assessment of the legality of the board's solemnizing practices to follow this item. So I would make that motion.
Second.
Second by Raddick. Discussion in open session. Yes, Mr. Taylor.
Thank you very much, Mr. Chair. So I guess my curiosity with this and reservation, not so much with where this may lead, but is the process by which we're asking to engage outside legal counsel outside of our county attorney, and typically engaged in challenges on constitutional grounds, often for an abridgment of religious liberty on some national prominence and scale from outside of our state. So I guess the reservation that I have is that we don't have and haven't seen a proposal of what you're considering or what you're thinking. I assume this is to invocate or to lead in public prayer to start off meetings. So the reason I ask that is because, and I'm reading here, it says to engage outside legal counsel to provide a confidential assessment of the legality of the board's solemnizing process or practices. And so I guess my first question would be if that has been called into question, the current legality of having a moment of silence. If that's what we're, okay. So, but the motion is asking for a confidential assessment of the legality of what I assume we're currently doing. So, but nobody has called into question that legality, is that right?
Correct. It's I believe, a beneficial and proactive measure that the board would benefit by here.
But I guess my question just comes back to if nobody's questioned the legality, or do you question the legality of what we're currently doing as far as the...
Yes, I have reason to.
Okay. And do you mind sharing with that?
I refer to Mr. Kukowski.
I guess I'm asking you what you think. I mean, one of the troubles with this is we're sort of, in my opinion, I think we're putting the cart a little bit before the horse. You're asking us to accept legal counsel. Legal counsel's here. You put the motion on here that you think that there needs to be an assessment of the legality, and so I'm just curious what you think is potentially the abridgment of legality on the current solemnizing practices.
Again, I think the board would benefit from hearing the assessment provided by legal counsel.
And my question again would be why? I mean, it's pretty plain. If you put a motion that there's a necessity to go to outside legal counsel, we haven't consulted our county attorney, I think that's a pretty fair question that the public would ask, right?
I think without a written policy as to a legal defense of something that could be, and I have been told is something that could be challenged, has not been locally, but could be potentially challenged, that it is a good practice to have something in writing that the board can refer to and the public can refer to as well. And again, I think the information this board will receive by accepting this pro bono legal counsel will speak for itself.
I'm just curious what's meant by
So is the agenda item for closed session an outgrowth of this first
Yes.
action? Okay. See, this is news to, I think, all the supervisors here. So I didn't know what the closed session was. So if we do not approve number one, then number two, closed session doesn't happen?
Correct.
Okay.
And I'm not sure as far as what all the issues are that will be discussed in the closed session. But in order for us to go into closed session, the threshold requirement would be that the issues either presently in litigation or that litigation is imminent. So we would have to meet that threshold and then we would go into closed session.
And I believe we meet the case for the second of those.
That is imminent.
Yes.
And what leads you to believe that?
Imminent.
Yes.
And what leads you to believe that it's imminent?
Advice received from First Liberty.
But that, I guess that's the problem to me with the process, respectfully, Mr. Chair, is you're asking us to accept pro bono services of First Liberty. You've consulted with First Liberty and received legal advice. So I guess the question is, why are we approving if you've already done so? And then secondly, typically you retain legal counsel because somebody's challenging something that you're doing. And if the goal is to invocate board meetings, I don't have a problem discussing that and looking at the ramifications and how that would go. But I just think that publicly we should know what it is that you're proposing and why we're accepting outside legal counsel when I haven't heard of an eminent challenge because we don't have something that currently. So I guess my confusion is more on process, not the content.
Well, I want the board to hear what I have heard, and this is the best mechanism to do that. And if we're open to the discussion, then we can have that discussion.
Is it in regards to a specific potential lawsuit against Woodbury County?
Mr. Fauci? No.
Because that's my concern is going into closed session. We have to meet the criteria to go into a closed session. And I agree with you. I've always heard it was, land sale personnel or litigation or pending imminent litigation.
Mr. Fauci, would you address the board?
Yes, thank you, Mr. Chairman. Good morning, everyone. The nature of today's discussion came about when your chairman became aware of a lot of the litigation work that we do nationally, including at the Supreme Court level. He had spoken with one of the senior counsel at my law firm, saying, well, what about what we do in this county? And briefly sketched out what that was. I was then brought into the conversation by telephone and explained that I was happy to give an assessment. We get contacted all the time by counties, cities, even state level clients across the county, asking for assessments when they become aware of litigation going on in other parts of the country, asking if there's any implications for any risk exposure regarding their current practices or lack thereof. And I offered to the chairman that I'd be happy to speak with him regarding that. He then, we entered into a private consultation in that regard, where I explored the pros and the cons of various approaches, including what this county currently does. Then when he asked if I would share that assessment with the board, having reviewed what your current practices are, I explained to the chairman that while I could discuss it in theory, could discuss it in open session, that typically when we travel across the country giving that sort of assessment, it's in the municipality's best interest to do so in a confidential setting through an attorney-client relationship, which might be a relationship that only lasts for an hour, just in terms of giving a confidential assessment. If in theory, hypothetically, if I were to advise that there's something you're doing right now for which you could be sued, if I say that in open setting, if there's anyone in this county who disapproves of that practice, then probably the next thing you'll hear about it is that they'd file a lawsuit. And then you're in a defensive posture right away, as opposed to a proactive measure. And again, we were involved with 434 legal matters last year. Our success rate is over 90%. I mean, this is an area of law that we know quite well. And I'm certainly happy to discuss how your current practice fits in terms of other jurisdictions nationwide, and to give you my assessment in terms of what best practices would be. So it's a chicken and the egg paradox that if you do it outside of closed session, then you forever, not only is it not privileged at that time, but you forever forfeit any attorney-client privilege regarding the subject matter. That's something that an attorney can only advise an organization in the context of a confidential setting. If there are third parties present who are neither the prospective client or the lawyer, any third party present, that automatically forfeits any sort of privilege for those discussions, and I just wouldn't see how that would be in the county's best interest.
So again, all I'm asking is for the board to hear this counsel.
In closed session.
May I ask another question? So you already asked for the legal opinion, correct?
Correct.
Okay. And now you're just motioning for us to hear in confidence what you've already heard. And we have no pending litigation. May I ask you a question? Thank you for being here. Sorry for the awkwardness of it. It's just, we didn't know where we were going with this. So.
Whether you're a client or not, I'm here at your pleasure and at your service. So,
how many of those 434 cases were litigated because a county and municipality held a moment of silence? In other words, didn't proactively invite other clergy, laity, members of a particular faith tradition, a chaplain. How many of those would you say?
that's something that you might want me to discuss more in closed session. I mean, if you want me to elaborate now, I can. I would advise against it.
Yeah, I would like you to elaborate now.
All right. The overwhelming majority of jurisdictions don't have a moment of silence. They actually have a specific prayer practice along guidelines that the U.S. Supreme Court has explicitly approved. The U.S. Congress, 49 out of 50 states, and well over 90% of the 3,000 counties in the nation all have a form of spoken prayer, many of them with a written policy as well. So the novelty of a moment of silence, which has in other contexts been struck down by various courts in other settings, it's in something of uncharted waters. So there aren't any published precedents against you. There are also not, in the legislative prayer context, there's also not a single published precedent in your favor.
Yeah, and I understand the legislative invocations can sometimes differ from local county bodies, but I was just curious along those lines, how many of those litigation actions had been against a county or a municipality because of their moment of silence?
It is, moments of silence are so rare in the invocation setting that it's not surprising that there is no clear precedent one way or the other. It's an issue of some things are clearly a safe harbor that have been explicitly approved by the highest court in the land. Other things are just uncharted waters, so it becomes an open question. We're in front of a lower court or a hostile judge. There's no precedent that would constrain them in that regard. There's always, everything that you do, there's always a risk of litigation. The question is, what is the degree of risk and how well is the risk managed? Precedents from a higher court that are clearly controlling and clearly are on point, that is always the approach that minimizes legal risk exposure, minimizes the chance of getting sued at all, and in the event that suit is filed, maximizes the chances in terms of how quickly it can be resolved, typically at that point on a motion to dismiss, because the reviewing court can see that there's a clear precedent on point, it clearly approves what's been going on, and they dismiss the lawsuit. Not only that, a lawyer who brings a lawsuit under such circumstances, now a pro se litigant can do whatever they want to do, but a licensed member of the bar filing a lawsuit under those circumstances, if the precedent is clear enough, could even be sanctioned by the court, and that tends to preclude that kind of harassing lawsuits being brought to begin with. But where there's no precedent on point, then there's no threat of any sort of sanctions for anyone seeking to create a legal episode.
So again, having kind of received some of that legal counsel already at this point, the motion is simply to accept the pro bono services. This motion does not regard to open closed session.
Just for purposes of an assessment at this point, by the way, I mean, if the board were to choose, at the end of that discussion, that might well be the end of it altogether. It's just all of the particulars with that regard. It would not be best legal practices to just discuss, as I said, there's risk exposure in every situation. To ventilate that for a client in an open setting is just never in the organization's best interest.
Further discussion?
So, sorry, I'm probably the slowest one on catching up here, but so if we accept the legal advice, that doesn't necessarily need to go into closed session. Is that what I heard you say, Mr. Chair? If we don't feel that it meets the eminent threshold, because I've never heard of a moment of silence necessarily being challenged, and I don't have a huge compendium of history. Do have a little familiarity as a U.S. Army chaplain with some of the religious establishment and exercise issues, but is that your understanding, is that we could hear in an open session what, I assume you traveled from outside of Woodbury County? And is that your understanding, Mr. Whitman?
As far as whether,
I mean, could the board still hear Mr. Kluski's, did I pronounce your name right? Legal advice in open session rather than going in closed session if it's clear that there's not an eminent threshold that's being.
yeah, certainly, if there's no requirement that a closed session, even if it's allowable, that would be held in closed session. Although what I'm hearing him saying is that in his professional opinion, it shouldn't be done in open session. The problem that I think we're having here is whether it meets the criteria under the Iowa code for closed session. So to answer your question, yes, it could be done in open session. The issue is more, is that the proper way to receive this information?
Maybe an email.
Mr. Kukowski, would you like to make any argument to the contrary?
Well, I certainly can't give you advice regarding Iowa law. As I'm not licensed to practice in the state of Iowa. Nor can I give you legal advice per se in a setting like this, because there is no attorney-client relationship that actually exists at this point. So I don't know precisely what the requirements are under Iowa laws. I've consulted with local governments nationwide. I've never encountered a situation where there was no mechanism whereby a local government cannot proactively seek a legal assessment of something and get a confidential legal assessment without simultaneously releasing it to the public. But then again, you know, this is the first time I've spoken with a county in Iowa. So in that regard, I would not know what Iowa law were required under those circumstances, and certainly, again, wouldn't be licensed to be able to advise on that question anyways. That would be more a question for your retained Iowa council. I mean, I can say broadly speaking, because this certainly wouldn't violate a sort of prospective confidence, is if I were in a position to give all of you advice regarding what your current practice is, how that compares to others across the country, and what that level of risk is now, and what could be done to mitigate that further. I mean, I certainly have recommendations that I could give, but as a matter of legal practice, I can't give legal advice to someone who's not a client, and I can't do it in front of third parties in any event.
Mr. DeWitt?
Mr. Woodman, is there anything that you're aware of that we're in violation of, we're in trouble of violating with our moment of silence? Has anything been brought to the county attorney's office?
I don't think that we've been asked to give an opinion on the issue, so I'm not aware that it's been reviewed, at least in the time that I've been in office.
Seems like the issue here is, for you to give your advice, you would need attorney-client privilege. And the way to do that is through a closed session. Is that your understanding?
More or less, yes. I mean, if hypothetically I get to see some red flags, and I would just say that on the record right now, then I assume that in a county of 100,000 people, there might be someone who's not happy with one or more members of the board, and perhaps people who have previously engaged in litigation against the county, and it would be pointing them to exactly what they could do in terms of initiating a lawsuit if they wanted to roll the dice and see what would happen. Which unfortunately is how many of these cases do in fact start. I mean, it's in most of the litigation that I'm familiar with along these lines, there is not precedent on point that is so indisputable one way or the other, because then people usually, many times, do not bring a suit under those sort of circumstances. They see something they don't like, and if it's something of a gray area of law, if they've got time on their hands and resources, or there are national organizations out there who make it their business to go, county by county and state by state. I'm engaged in litigation with almost a dozen cases with groups like that in various places in the country right now, who have a mission statement regarding things of this nature. And the Supreme Court has said that moments of silence tend to have a religious purpose, and that's why these things have gotten to the Supreme Court previously on Establishment Clause grounds and lost.
Can I ask you another question, Mr.? So in your reaching out to First Liberty Institute of all the legal counsels available nationwide, including our county attorney, did you have a specific proposal in mind that you were asking? Because one of the things, I guess I assumed that it was in order to publicly invocate or have a prayer spoken either by invited clergy or a current sitting elected official, or was it that you reached out because you wanted to see whether a moment of silence was legal or not?
I wanted an audit of the county's practices that would provide us with some sort of recommendation.
So you don't have a necessary
It
proposal?
seems to me as it might have been to you that moments of silence were actually
based on the legal counsel that you received.
Yes. Which I would like the board to hear. The motion is to accept the pro bono services of First Liberty Institute to provide a confidential assessment of the legality of the board's solemnizing practices. Is there any other discussion? All those in favor say aye. Aye. Opposed say nay.
Nay.
The motion fails 1-4. DeWitt, Taylor, Potabom, and Raddick opposed. At this point, Mr. Kukowski, is it fair to say that you would not prefer to advise the board in open session?
Fortunately, under these circumstances, I don't think I'm able to do. I'm able to do that. That doesn't mean that I might advise that you're in a high-risk environment right now, only that there's always risk. And there are always things that you can do to mitigate that risk. A couple things would be real low-hanging fruit in this situation. Things that if you were to hear, I think, you would probably react by saying that sounds like a common sense measure, and it just no one ever was thinking about it previously. But again, in this sort of posture, I mean, I can't just give it legal advice to the general public like that. I mean, if things were to later become adverse, that would not be in best keeping with legal practice in terms of how a lawyer should ask, in terms of how a lawyer should act, is to broadly disseminate legal advice to the public. You typically see TV commercials that nothing in this is to be construed as legal advice.
Well, thank you for flying from DC to see our courthouse.
It's a beautiful building.
That the board will
It is a gorgeous, I'll tell you, as I see a lot of local governmental structures around the country. This, I'm guessing, is some sort of historical building.
National landmark and celebrating our 100th anniversary here, and so please come for that.
Congratulations in
Thank you.
advance for that. No, it's a beautiful facility, and it's my first time in this part of the state. It's most counties don't have a building that they would, or at least many, I can't say most, I don't know if it's 51% or not, but many county buildings I've been in are not ones that they would want to showcase to the general public the way we went here. So congratulations in advance for the 100-year anniversary in that regard. You all certainly have my contact information, so if things would arise in the future, we're certainly happy to discuss things at that time. Thank you very much.
Thank you.
I'm disappointed that the board will refuse to hear the free and accurate legal advice